speak to you today about the state of play of space governance in Ghana, or perhaps a better title would have been the lack of it. And I will try my very best to stick to my 7 minutes that I've been allocated, but be very difficult. Space is such a complicated topic. So before we trickle down to Ghana, it's good to put this in context. Dr. Mahama touched on some of this. I'll just quickly run through. Why are we talking about space policy, strategy, law? What is its relevance? Well, its relevance is because it's a moneymaker. The global space industry right now is $350 billion. That's what it's worth at the moment. And Morgan Stanley forecasts that this is set to increase to over $1 trillion by the year 2040. Now, if we focus on the continent, the African space industry is around the $7 billion mark. And in just a few years, it's set to hit the $10 billion mark. That's not chump change. And Ghana and a lot of the other African nations really want to increase their slice of the pie. And one way of doing this, or perhaps the best way of doing this, apart from having well-qualified scientists and engineers, is to have a superb, flexible, dynamic legal and regulatory framework. Next slide. Unfortunately, in Ghana at the moment, there is neither a national space policy nor is there specific space legislation. Now, what I mean by specific space legislation is that there is not one overarching act which touches on emerging space activities. If we go to the next slide, we'll see that there are a number of related laws and policies. So for example, here in Ghana, where I'm currently based, there is the Electronic Communications Act of 2008. And that deals with radio spectrum for telecommunication. Now that relates to the use of outer space. We also have some relevant policies. As a member of ECOWAS, the Economic Community of West African States, they published a scientific policy back in 2011. And more close to home, we have a national science, technology, and innovation policy. Our policy was first published in 2009 and it was revised in 2017. And there are a few points that are worth mentioning here. Now, although it's not a space policy, it does relate and highlight several important things. Firstly, it provides for an advisory council to the president on science, technology, and innovation. It also provides for a fund to fund research into science, technology, and innovation. And this relates to something Dr. Mahama mentioned in his talk, the need for the continent to transform from a space consumer to a producer of space services and products. And hopefully that this science, technology, and innovation fund will really be a stimulus here in our country to contribute to that transformation. Our policy also did highlight or provide for a 3-phased space plan, the first 2 of which have been achieved. That was the establishment of the Ghana Space Science and Technology Center and the transformation of that center into an institute. And those 2 objectives have been achieved. The third objective of this mini space plan was to establish a Ghana Space Agency. And unfortunately, to date, as far as I can tell, that has not been done. So no specific space policy or space legislation in Ghana, but we do have some laws that are related and some policies that we can build on. So I won't spend too much time on international space law. I think it's something that we can delve into in the question and answer session. But it's important to highlight that, of course, international space law does exist. There are numerous multilateral and bilateral agreements. There are codes of conduct, norms. There's the ITU regulations, for example. But perhaps the most important of international space law are the 5 UN space treaties, the primary one being the Outer Space Treaty of 1967. Now, if these international space laws exist, the question then is, why are we talking about domestic law? Why do we need domestic legislation, particularly if we're not a very strong spacefaring nation? Well, first of all, international law only applies at the international level. It doesn't apply for dualist countries, of which Ghana is one. It doesn't apply domestically without incorporation. Secondly, we want to expand our space industry. If we remember the pie charts at the beginning of my presentation, we could see that the African continent has a very small percentage of a space budget. And we also have a very small percentage of the global space industry. If we want to increase that, we need to provide investors, both domestic and foreign, with some type of legal certainty. They need legal parameters, and those legal parameters can be achieved by domestic legislation. Second reason why we would like domestic legislation is that is probably the best way, not the only way, but probably the best way of implementing states' international obligations. Now, Ghana has signed some of the UN space treaties, notably the Outer Space Treaty, for example, but we have not ratified it. So technically, Ghana is not bound by the provisions of those UN space treaties. However, by being a signatory, we have undertaken at the international level to aim to adhere to those principles contained within. And considering that Ghana has made it clear that it intends to expand its space activity, it's presumed that they're at some point going to ratify the Outer Space Treaty as well as the other 4 UN treaties. So if we want to ensure that we are meeting our international obligations, we need to implement domestic legislation. And if I can just focus on one specific aspect of the Outer Space Treaty, which I think is important to underscore the reasons why domestic legislation is necessary, is that states, once they ratify the treaty, they are responsible for national space activities. Now, national space activities specifically includes the activities of non-governmental entities, i.e. private companies, for example. Now, this is a significant departure from international law generally, where states are rarely responsible for the acts of private entities. In international space law, states are responsible for the space activities of their private entities. And in order to pass on that responsibility or that liability, they want to ensure that they have domestic legislation whereby if they are held responsible and liable at the international stage, they can then recover, whether through insurance, indemnity, recover from the private entities that rendered them liable at the international stage. And lastly here, domestic legislation is important to protect the public interest. It was mentioned that by Dr. Nyampong that space is widely perceived as a global commons, similar to the high seas. And the treaty, the Outer Space Treaty, states that it's supposed to be used for the benefit of all nations. So we want to make sure we protect this global interest and ensuring that space, especially low Earth orbit, is not rendered inaccessible. We want future generations to benefit from, air navigation, access to the internet, GPS, et cetera, and emerging technologies that are not even here yet. And that is the reason why legislation can help us to ensure that we protect the use of outer space and that things such as the Kessler syndrome, which we can talk about later, are not triggered. Because we're short on time, I won't go into details here, but this slide demonstrates that Ghana has been active in the space industry for almost a decade, perhaps even more. There's a few examples that are not on this slide. And although we are not a significant space power, we are taking baby steps. And Ghana launched its first satellite back in 2017. It was a private endeavor, a private university, and which was the GhanaSat-1. And it's hoped that they will continue with the GhanaSat-2, which will tackle things such as illegal mining, unlawful or illegal fishing, human trafficking, deforestation. These are some of the benefits to be achieved through the use of outer space. So if Ghana has been achieving some of these things and working towards the achievement of more, then we really need to get a legal framework in place that provides a flexible and open legal environment to attract attract investors and expand the market for entrepreneurs, engineers, manufacturers, and provision of space services. So if we are going to have a domestic law, space law, beyond simply establishing a space agency, which is to be welcome, but we need to go beyond that, what should it include? Well, Ghana doesn't have to start from scratch. Many countries have domestic space legislation. Several have them that go beyond the space agency. And both the International Law Association and the UN, through some resolutions, have outlined, in their view, what should be included or would be helpful to be included in domestic space law. And I'll just highlight a few of them here. Definitely, there should be some regulator that licenses and supervises space activities, both within the jurisdiction and by Ghanaian nationals. You know, what space activities are going to be permitted, when will they be permitted, by who, or who will be allowed to carry them out, how are they going to be supervised, what happens when an actor who wants to undertake space activities does not comply with the legislation, what are the sanctions? We also need to ensure that our space laws link with related areas such as intellectual property, data protection, national security. There was a question, I believe, in one of the last presentations from someone asking whether, for example, a Ghanaian national can work in the space industry in another country. Now, it's an excellent question. Of course, we'd like to do partnerships. It's been mutually beneficial to Africa as well as other regions in the world. We are capacity building. There's a lot to be learned. However, we also have to think about things such as technology transfer and classified information. There are some countries that place limits, restrictions on what information can be shared and transferred in capacity building exercises. And that is something that those who will be debating and drafting Ghanaian space law may want to think about. So just in the interest of time, I'll leave that there. And then just one last slide, I believe. Just to highlight that it's not an easy feat. It does require a balancing act. The law that eventually is put into place needs to be flexible enough to attract investors to Ghana. Otherwise, they will take their money to other countries that have more favorable legislation in terms of liability and indemnities and insurance and safety standards. But equally, it has to be thorough and rigorous enough and not too liberal that safety, security is compromised. So it does require a bit of a balancing act. And in that regard, I think that we need to build, in addition to our technical capacity, we need to build our space law capacity. So those who are negotiating at the international level, multilateral agreements, and those who are drafting domestic contracts and domestic law are aware of some of the nuances that need to be considered so that we can have an enabling legal framework. Thank you very much.